I will turn it over to someone who, again, you all know very, very well. And so no introduction necessary on my part, but I'll turn it over to Layla Sadat. Thank you very much.
Thank you, Jim. Good afternoon, everybody. Mark Ellis of the International Bar Association was originally scheduled to do this introduction, and I'm sorry that Mark wasn't able to make it, but I am delighted that I have the privilege of introducing our very distinguished luncheon speaker. Many of you already know Judge Hans-Peter Kaul of the International Criminal Court. What you may not know, and I'll talk a little bit about his bio, is what an extraordinary person he is. He was a very good friend of Whitney Harris, and in fact, I was very touched when both Hans-Peter and his wife Elizabeth came to St. Louis for Whitney's memorial service, which was really quite special. He led the German delegation during the ICC negotiations. Before that, he was a distinguished member of the German Foreign Ministry, and he was elected to the court in 2003, then re-elected in 2006, served as vice president of the court from 2009 to 2012, and now, as I understand it, he is in 2 trial chambers that literally cover all 8 situations. 3 trial chambers that cover all the situations in the court. He may not know that I know this, but he's also been referred to in a very interesting law review article that my good friend Klaus Kress wrote as the individual that really succeeded in pushing the German government to embrace the International Criminal Court project. And as you know, Germany is one of the ICC's most staunch supporters. So I could go on, but you'd much rather hear from him than from me. It's my great pleasure to introduce Judge Hans-Peter Cowell, and please join me in welcoming him to the podium. Thank you.
Thank you, Laila. Well, in this sixth dialogue meeting, again, so rich, so substantial, so thoughtful, we have considered together lessons learned, yes, the legacy emanating from the Special Court for Sierra Leone. And I believe that these lessons learned may also contribute to and strengthen in many ways the ICC of the future. Now, let me start with a basic but maybe not unimportant question. When will the US become a state party of the ICC? Well, it is exactly this question which was put to me in an interview by the Süddeutsche Zeitung, a German newspaper, published on 28 June of this year at the 10th anniversary of the entry into force of the Rome Statute. And here you have the piece, and it shows Fatou Bensouda as the key person on her swearing in. And the answer that I gave to the question is essentially the same as my assumption today. Regrettably, there is no chance that the US will join the court in the foreseeable future. But I assume, no, I believe that the US will be a state party at the latest around the year 2040, almost 40 years after the entry into force of the Rome Statute. It took the US also almost 40 years to ratify the Genocide Convention. But when this happens, it seems quite likely to me that China will already be a member of the court. I continue to be in regular contact with well-informed Chinese interlocutors. And already in 2003, when then President Kirsch and I were invited to Beijing, an official invitation, we were not invited to Washington, the legal advisor of the Chinese Foreign Ministry told us, quote, China, even as a non-state party, wants to be regarded as a friend of the ICC. We will follow a wait-and-see policy for some time and observe whether the court will behave as a purely judicial institution or whether it engages in politically motivated prosecutions. If the latter is not the case, the time for Chinese membership may come. End unquote. More importantly, in the next decade, there will be further profound changes in China, a new leadership replacing the old guard, a more democratic society. These developments may lead to Chinese membership in the ICC system sooner than expected. And I'm grateful for the chance to share with you my personal view and hopes on the ICC of the future. For this, I will address three sets of issues. One, what about the efficiency and administrative culture of the ICC of the future? Two, what are some possible or likely developments with regard to judicial proceedings or with regard to the applicable criminal law? And three, what about the relationship between the ICC of the future and states parties, states in general, or the Security Council? And with regard to the third question, please remember what Hans Cowell said yesterday on the Rome Statute and the obligations of states. And Hans was kind enough, where is he? Hans was kind enough to last night to slip under my door a copy of his keynote. And having read it again, please permit me to put on record already now my full agreement with his comments on the ICC and the obligation of states, and I may come back to this. Well, it is obvious that discussing the ICC of the future, I will be bound to set out some assumptions, likely scenarios or other predictions. At the same time, there is a problem with such forecasts and prognostications. And as a wise man once said, was it Einstein? I don't remember. The problem with prognosis is that they deal with the future. Well, we all know that the future is unclear, incorrect assumptions and errors are always possible, but it is my hope that such a look into the future, such a look into the crystal ball of the ICC will be interesting, maybe a little bit thought-provoking. First part. The work of the ICC of the future will be characterized, in my view, by much more efficiency and a better work culture, this in a quite comprehensive sense, and I will give some examples. Why? Why is this so? Well, not because of control efforts of states parties, certainly not, but out of sheer necessity, which the leadership of the court will have to recognize or is about to recognize. And one major positive factor will be, for example, more respect for and much better compliance with the one court principle, both internally and in all contacts and communications with external stakeholders. Forgotten will be the days when admittedly objective observers, sometimes including myself, could have the impression that the office of the prosecutor, the presidency, the registry, and the chambers were seeking to be as separate small organizations of their own. While these centrifugal tendencies occasionally have done much damage and have caused delays in the build-up of the court of the future will appear unified as one court with the common mission to contribute to effective investigations and judicial proceedings with regard to core crimes and thus to the fight against impunity. And this presupposes that possible internal differences of view are settled within the court and that its standing is not negatively affected by the perception of an internal divide at the court. Instead, a general atmosphere of mutual trust, confidence, and reliability between all elected officials, organs, units, and staff of the court will, in my view, contribute to more efficiency. Next point, the budget of the court. Yes, budget preparation, financial control, and proper budget implementation, this matters, and I say it also as a judge. In the past decade, those involved had to learn in a difficult process of trial and error that a good budgetary process and proper budgetary means are not self-understood. Even today, the process of the preparation of the court's annual draft budget absorbs year after year too much work, too much time, and often the patience of too many officials, in particular if competing priorities arise. I am, however, convinced that the ICC of the future will have a proper budget methodology, achieving a best practice standardization of the budget elaboration. And such a budgetary positive routine will set free much positive energy, in particular work capacity for the core functions of the court, namely prosecution activities and judicial proceedings. In addition, more financial means will facilitate the work of the court, as the forthcoming dissolution of the ad hoc tribunals and hybrid courts will leave the ICC as the only international justice mechanism, and this will alleviate the burden of the international taxpayer by around 300 to 400 million per annum. In the ICC of the future, the registrar and the registry will demonstrate consistently a proper understanding of their role, namely that the registry is not an independent organ of the court and that the registrar is, quote the statute, the principal administrative officer of the court acting under the president, not less but not more. In the future, there will be a work procedure in which the registry, without fail, acts as the main service provider to the judiciary and the office of the prosecutor. It will thus be a positive normalcy that all activities of the registrar, including on external relations, are aligned with the strategic and policy decisions taken by the judiciary, the presidency, and where appropriate, the prosecutor. It is nowadays generally recognized that international courts need strong and courageous leadership. This is true in particular for the ICC. There is more and more agreement in The Hague and elsewhere that the role of the presidency really goes beyond protocol and representational activities. In the future, it will include, and there is no doubt in my mind, an active approach with regard to all problems and challenges facing the court, including on difficult issues such as the budget and the proper administration of the court and others, in particular the judicial proceedings. Needless to say, the lead role of the presidency must be exercised in close coordination with the prosecutor, whose full authority over the management of his or her office shall be respected and must be respected. In the future, the court will have to live up to two other requirements. First, a consistent practice of trust, but verify that the tasks and challenges arising are indeed addressed. Second, there will have to be more respect for basic work requirements such as, you hear a German speaking, discipline, diligence, punctuality, reliability, respect for deadlines and cost awareness, observance of the working hours, and no absence from work without proper permission. I think non-compliance with the aforementioned is particularly unfair to all who do their job as usual. There is, however, a related necessity for the elected officials of the court, and this includes the judges. The leadership of the ICC of the future will have a much better understanding how important it is to motivate the staff, to encourage all concerned, to lead by example, and thus take the personnel with you. Experience shows that good work morale and staff feeling appreciated at work is the most important factor for efficiency and performance. This is valid for Google and Apple. It is also valid for the ICC of the future. There is another development which quite soon will foreseeably enhance the work culture and efficiency of the ICC. Already in 2015-2016, the ICC will have, and here I use a term coined by Ben Ferencz, don't greet him from me, the ICC will have its own temple of law, namely permanent premises which are in full conformity with the functional, organizational, security and other needs of the court. Maybe I'm allowed to mention in all modesty that from 2003 to quite recently I have invested enormous work and efforts to drive this project ahead, the key parameters of the premises, the site, the financing, professional project management, and the international architectural competition, and only last Friday a contract was finally awarded to a construction company. The ICC will thus be the first international criminal court in the history of mankind which will have its own purpose-built permanent premises built for generations to come. And as this project currently is on track, there is, as usual, no more acknowledgement of my crown-playing role, but I do not mind. Maybe they may invite me to the inauguration ceremony. Part 2. In this part, the main part of my presentation, I will set out some possible or likely developments which in their combined effect will probably make the judicial proceedings of the ICC of the future much more efficient and expeditious. In the ICC of the future, chambers will have certainty to receive the necessary resources to properly and expeditiously carry out their functions. It is expected that not a single hearing, if necessary, simultaneous hearings of chambers on the same day will be delayed or adjourned because of lack of courtroom staff or other necessary resources. Second, victims' participation and the related current practice of the court will undergo a significant change to a more meaningful participation. The current practice is, in my view, largely characterized by a deplorable lack of genuine victims' participation. Instead of such genuine participations, which may enable victims to see justice being done with the related potential of healing, there exists a bureaucratic, slow and costly systems of victims' admission in which the victims at best are virtually present in the proceedings. They are routinely represented by a new subcategory of counsel, the so-called legal representatives of victims, which all too often do not maintain a proper contact with the victims represented. And in the future, various ways and means will be explored to achieve more proximity with the proceedings, to bring the victims closer to effective participation in the judicial proceedings, in particular through the possibility of collective participation in intervention of elders or community leaders who represent a group of victims throughout the proceedings, through more consistent and conscious appearance of victims in hearings also as witnesses, through the presence of elders and of affected communities, or the presence of victims elected as representatives of victims groups in the courtroom or in the gallery. To this end, a network of NGOs could assist the victims and the court in facilitating the organization of those visits to the court. Further, through in situ hearings of chambers or judges, in which the judges orally and directly receive representations or the views and concerns of the victims, this in the language of the statute. And finally, through the holding of confirmation of charges or trial hearings or parts thereof, also in situ. In the court of the future, proceedings will be much more expeditious than they are today. In particular, two somehow related problems which have already caused many complications and delays will no longer exist. First, so-called phased investigations, in which the office of the prosecutor seemingly seeks, maybe I should say sought, to assemble just enough evidence to achieve the next threshold, instead of working full power ab initio to achieve evidence beyond reasonable doubt. Second, the questionable practice to request time and again reductions across the board, in hindsight often excessive, inconsistent, and sometimes also unfair to the defense. With regard to so-called phased investigations, there is still an appeals chamber decision at our court explicitly allowing the continuation of investigations after the confirmation of charges. Fortunately, there is a recent appeals decision in the case of the prosecutor versus Calixte Mbarijimana, in which the appeals chamber clarified its position on this point by specifying, quote, that the investigation should largely be completed at the stage of the confirmation of charges hearings, unquote. And I have argued that it is risky, if not irresponsible, for the prosecution only to gather the minimum amount of evidence to move to the next phase of the proceedings. And it is my expectation that this problem will no longer exist, and that the quality of investigations will improve as the court goes forward. An investigation as focused and effective as possible from the beginning, with a strong investigation team, will also largely eliminate a problem which until now is plaguing in particular pre-trial proceedings, namely pervasive, often exaggerated or precautionary reductions, which often have been a major problem. In particular, in pre-trial proceedings, their consideration has absorbed inordinate time and energy of all concerned. However, if investigations are more advanced and almost complete before cases are commenced, then the need for such extensive reductions is reduced, maybe even eliminated. Witnesses in vulnerable locations have time to be moved, disclosure consent form can be obtained, tactical decisions can be made as to whether using vulnerable witnesses is necessary. Reductions will be then used in a limited and much more pragmatic way than they are today. Therefore, in the future, disclosure in unredacted form of all relevant material will probably take place immediately after the confirmation of charges hearing. Trial proceedings may commence 2 or 3 months thereafter, that is, after the defense is afforded a reasonable time to prepare the case. I also foresee much more effective investigations and cooperation work in the Office of the Prosecutor through maybe, this is now a proposal of mine to the Office of the Prosecutor, through a doubling of the staff of the investigation division, currently 110 positions, and in the jurisdiction complementarity and cooperation division, currently 31 positions, only 15 professional positions. There is already an emerging awareness also among state parties about the following. With this limited staff for investigations and cooperation necessities, and please do not forget, these ICC staffs are also entitled to annual leave, to training. Some may need a timeout for legitimate reasons. How is it possible with around 100 staff to fully cover the investigation and cooperation necessities for 8 situations, 14 outstanding arrest warrants, or another 8 situations under preliminary examination? Consequently, as an ICC judge, now serving for almost a decade, as somebody who believes to know this court a little bit, I fully encourage Ms. Bensouda, our distinguished and highly respected prosecutor, to seek in the years to come such a doubling of your staff, in particular in these key areas. The work of chambers, which are on the receiving side, is naturally fully dependent on effective and professional investigations, prosecutions, and related cooperation efforts. And I am quite confident that also this necessity can be explained to the Assembly of States Parties. They will understand this necessity, compelling necessity, reflected in a metaphor, in a picture often used at the court, namely, quote, "The office of the prosecutor is the engine, professional and effective investigations are the fuel of the court." Unquote. Yes, I believe that the ICC of the future will have more and enough fuel. Already the combined effect of all these positive changes will make the judicial proceedings more convincing and more expeditious. Positive change is also possible with regard to the future work of the judges. It is indeed my expectation that a careful pre-selection of judge candidates through the Advisory Committee on Nomination of Judges established by last year's ASP held in New York will increase the chances that only candidates who, beyond the necessary formal qualifications, have also a solid inner compass and a proven commitment to the cause of international justice may be elected as judges of the ICC of the future. Improvements are also possible in the work methodology of the appeals chamber. The appeals chamber of the future should and will, in my leave behind, the somewhat minimalistic approach of decisions on appeal, which has been existed in past years, and in which all too often a tendency has become obvious to seek an easy way out. For example, Bill Chabas, he's sitting here, he has found out that in 2009, 5 appeals chamber judges produced altogether 79 pages of substantive legal considerations. All the rest quite extensive reports on procedural history or repetition of the arguments of the parties. Thus, the appeals chamber of the future will hopefully demonstrate a consistent will to consolidate, to develop the jurisprudence of the court with substantial decisions, indeed clarifying once and for all the complex issues as they arise. On the basis of these positive developments, which may occur as a result of sheer necessity or more insight and experience, or even both, it is quite likely, at least in my view, that proceedings and trials will in the future be more expeditious. As with many cases at the ICTY, it took ICC chambers in the first 2 trials, again 5 or 6 years, to come to a verdict or close to a formal judgment. Pre-trial proceedings took regrettably around 10 to 12 months. In my view, this is unsatisfactory. It will mean significant progress if the duration of the trial of mass crimes can be reduced at the ICC of the future to approximately 3 years, in particular through proper case management. And this includes, first and foremost, a strong role and control of the proceedings by the judges. It means also streamlining and accelerating the disclosure process and dealing expeditiously with the related issue of reductions. The overall time for trials could be reduced, however, as well through the use of a single judge for the preparation of the trial proceedings and the use of case managers and legal officers with specialized expertise on, for example, victims' participation and protection issues. Likewise, it is, in my view, not impossible to reduce, through focused works of all concerned, the length of pretrial proceedings maybe to around 6 months. Here I would like to refer in particular to my earlier comments on the need to abandon the previous practice of so-called phase investigations. Needless to say, also in the future there will be many imponderabilia and unforeseen developments which may cause delays. The task, however, is clear and remains clear. The duration of judicial proceedings now is one of the most corrosive, if not damaging, factors for the standing of the court, and all must be done to come closer to a trial without undue delay, as referred to in Article 67 of the statute. The quality of judicial proceedings will also be better because judges, legal support staff, and others may have benefited from regular and professional training seminars organized, for example, by the International Academy Nuremberg principles. The mandate of this new institution will be to promote and to disseminate the legal and moral legacy of the Nuremberg trials of Robert Jackson, Telford Taylor, Whitney Harris, Ben Ferencz, and Bill Kaming, who is who is with us at these meetings. As some of you have been in Nuremberg, including Stephen Rapp and Bev, and John Barrett is also involved, you are aware that such training seminars for ICC members will probably be one main core activity of this new academy, which will officially be founded in 2013, and another important activity of the academy will be customized information work on the objectives and functioning of the court, tailored to the needs of specific target groups. And last night, I had a good exchange on this with David Crane, and it was, in my view, not difficult for us to conclude that the Academy and the Robert Jackson Center may be some kind of natural partners to work in the same direction, maybe even work together. With regard to the substantive criminal law applicable before the ICC of the future, one significant development is already known. At the end of this decade, the ICC will have, at least to a certain extent, a somewhat symbolic jurisdiction with regard to the supreme international crime, the crime of aggression. The necessary 30 ratifications of the Kampala amendments and the necessary affirmative vote of at least 2/3 of the state parties should not be too difficult to achieve, and Germany will ratify the amendments at the latest in 2013. It is, however, my assumption that the court may not yet have, even around 2030, a concrete case in which a crime of aggression pursuant to Article 8 bis and 15 bis and ter of the Rome Statute will be prosecuted. Why? Well, experience shows that quite obvious, clear-cut crimes of aggression reaching the high threshold of Article bis, such as in the past the Iraqi invasion of Kuwait and the crimes against peace, such as the German attack on Poland on 1 September 1939, are not committed very often. The existence of ICC jurisdiction with regard to the crime of aggression, even only to a limited extent, will nevertheless have significant positive effects. Whenever there is a questionable use of armed force against another state, international commentators, international public opinion will raise the question whether the leadership persons in question may have committed a crime of aggression. And one can hope, and this is my personal hope, that this may reduce or contain, at least to a certain extent, the readiness of political or military leaders to use brutal armed force for their goals. With regard to crimes against humanity pursuant to Article 7 of the statute, it is my hope that the current majority jurisprudence established in the Kenya case will have become obsolete and overturned by future ICC decisions. To blur or to do away with the fundamental difference between crimes against humanity and multiple ordinary crimes is, in my humble view, simply wrong. A vague formula that any kind of non-state actor may qualify as an organization within the meaning of Article 7(2)(a) of the statute that, quote, has the capability to perform acts which infringe on basic human values, unquote, remains unconvincing to me. This applies also to the mafia. In the future, it will hopefully become clear that this type of jurisprudence, which also brings along to extend ICC jurisdiction indefinitely and beyond its capacity, is not sustainable. And in this regard, However, I note with appreciation that more recent ICC decisions have consciously and quite consciously shied away from using the vague aforementioned formulations that I mentioned. The jurisdiction of the ICC of the future will continue to be limited to the 4 core crimes as enumerated in Article 5 of the statute. Further attempts, as we have seen, to include terrorist crimes as such and suggestions, even suggestions, to include financial crimes in the ICC jurisdiction will go nowhere. Other mechanisms will have to be found to prevent impunity for maybe enormous financial crimes which seemingly continue to be committed day by day. Third and last part, states, the Security Council and the ICC. And remember what Hans Cowell has said yesterday. The ICC of the future, this is the first point, will be stronger and more accepted because around the year 2030 it will probably have around 140 states parties or more and not 121 as today. What is even more important is that there will be a much more positive attitude of the states parties towards their court. Forgotten will be current attempts of some state parties organized in a so-called G5 group of major contributors or G6 group, including Canada, to impose a zero nominal growth policy on the court. This, despite the fact that the workload of the ICC is constantly increasing, and also despite the fact that the sums which may be saved through such a zero nominal growth policy are ridiculous small. They are indeed irrelevant compared, for example, with the costs of fire brigades in capitals of states parties or with the costs of one single modern tank. Furthermore, the expected shutting down of the ad hoc tribunals of the Special Court for Sierra Leone, of the Lebanon Tribunal, and of the extraordinary chambers in the Court of Cambodia in the near or foreseeable future will dramatically reduce the costs for international criminal courts and alleviate the budget of ICC states parties by at least $250 to $300 million per year. Governments and finance ministries of states parties will gradually understand that henceforth more funds are available and that complementary ICC jurisdiction is soon worldwide, as Sheriff Basuni has said, the only remaining mechanism to promote more international justice. There is therefore good hope that there may be enough briefing space to provide the ICC in the decades to come with a solid financial basis. There is a further area in which a change of behavior of states parties towards the ICC is necessary and likely to come about. And this concerns a quite obvious, if not excessive, current tendency of certain states parties and their delegates to micromanage, to interfere in internal matters of the court, or demand excessively all kinds of written reports on all kinds of complex issues. And this problem is compounded by the activities of a significant number, yes, proliferation of subsidiary bodies for inspection, evaluation, and investigation of the court concerning its efficiency and economy. Believe it or not, in 2012 there exist some 12 to 15 of such bodies, working groups or subgroups. Needless to say, this imposition of additional work on the court often absorbs almost entirely the working time of senior officials and staff, thus having a detrimental effect on the regular functioning of the court. There is, however, also here light at the end of the tunnel. There are hopeful indications that in the next years it will be possible to re-establish a fair balance between the independence of the court and the legitimate desire of state parties to provide oversight management as foreseen indeed in the statute. A fundamental strengthening of the ICC may also become possible in a crucial, if not decisive area. Arrest actions supported much more vigorously by state parties and even non-state parties, such as the US. Informed observers note since some time a growing awareness in the ICC community that the total dependence of the ICC on effective international cooperation, notably with regard to arrest and surrender to the court, needs to be addressed. Currently, only 6 warrants of arrest have been executed, 14 remain outstanding. And this points to the necessity that states one day will form or make available task forces to arrest suspects for the ICC, just as it is now routine to use such forces domestically against armed criminals. The fact that the US have recently sent a small number of military advisors to Uganda to train forces for the possible arrest of Joseph Kony and his commanders is encouraging. It is a step into the right direction. Other measures will have to follow in the understood interest not only of the court. For the ICC of the future, there is also room for improvement of its relationship with the Security Council, or even the treatment of the court in particular by the 5 permanent members. The court is an independent and non-judicial and non-political judicial institution acting in the interest of the international community. And it should not be treated, it must not be treated as a political instrument of the Council. To use the court as a tool of the Security Council will inevitably politicize it, make it controversial, and damage its chances of becoming a universal institution. One must hope especially that future Security Council referrals of situations will be decided upon with wisdom and a visible sense of responsibility. In my humble view, this means in particular that the responsibility of the Council to support the work and intervention of the ICC does not end with the adoption of the referral resolution under Chapter 7 of the UN Charter. And why is it not possible, as Hans Cowell suggested yesterday, that the Council may adopt, if necessary, after a due waiting period, a resolution under Chapter 7 ordering the government of Sudan to arrest and surrender the Sudanese suspects sought with an international warrant of arrest. Furthermore, Article 24 of the UN Charter leaves no doubt that the Security Council, when exercising its authority for the maintenance of international peace and security, acts on behalf of the members of the United Nations. The logical consequence of this is, at least in my view, that the costs for ICC interventions after a Security Council referral should be borne by the World Organization and by its members, and not by ICC state parties alone. Dear friends, I would like to conclude with the following. I believe that in a foreseeable time, around the year 2030, maybe earlier, we will see a stronger, more effective ICC, working more successfully in a more favorable international environment. Yes, and I'm prepared to admit this quite openly, I do this regularly, there are problems and weaknesses at the current ICC. Yes, progress and positive change, improvements of our work continue to be difficult. Setbacks may occur. And compared with the violent crisis in this world, compared with the forces of realpolitik to which Sheriff Basuni has alluded this morning, the court will always be small and weak, more a symbol, more moral authority than real might. But the ICC of the future is possible, despite so many difficulties. It is encouraging that the abbreviation ICC has become, in only 10 years, a universally recognized symbol. The court has become some kind of worldwide visible, known and lighthouse for the message that nobody, no president or general is above the law, and that there shall be no impunity for core crimes, regardless of the rank and nationality of the prosecutor, of the perpetrator. This is the standard-setting message of the ICC, and one should not underestimate its impact, and it is only logical that this message is not very much to the liking of those who continue to regard the use of brutal armed force as a possible means for their political objectives. To conclude, yes, steadfastness and patience. Much patience will be necessary to achieve the ICC of the future. And even after 2015, when my office as judge will have ended, I will follow the development of the court with hope and a good spirit. And should it happen that the positive changes that I have mentioned today take too long, then I may, if necessary, pass away, but still with hope and in good spirit. So be it. Thank you very much.
Wow, thank you very, very much. What a great way to bring these, or start to bring these dialogues to a close. At 2:30, we will do exactly that. We will issue the declaration and bring these dialogues to a close, but don't worry, only for deliberations until next year's dialogues. Therefore, this is my opportunity right now, and so if you would indulge me, I would appreciate it, but I would like to say a few thank yous. First of all, I would like to recognize our sponsors, for without their generosity, these dialogues certainly would not have gone forward. And so they include the American Red Cross, the American Society of International Law, Chautauqua Institute, Clayton Sweeney, the Enough Project, Frederick K. Cox International Law Center, the International Bar Association, Int Law Girls, Jamestown Community College Foundation, Josh Hines, Planethood Foundation, Syracuse University, Titan X, and the Washington University School of Law, and of course in association with the United States Holocaust Museum. So please extend a hand to all of this. I would also like to, at this time, to recognize the staff of the Jackson Center for all of the hard work that they have done. And I want to point out that when I said recognize the staff, Carol, who was standing at that curtain right back there, ducked out. Now she's back. There we go. But I would like to recognize Carol Drake, Deborah Pecos. Deborah, stand up. Deborah, you stand up. Deborah Pecos. Jennifer Champ. is Jennifer Champ. There we go. And our intern, Emily Gabler. Where's Emily? There she is, right there. Okay. Now, I would also like to recognize, again, many volunteers who, without the help of these volunteers, a lot of work behind the scenes. Many of you have seen a lot of their work with many trips to and from the airport. And so I would like to recognize these volunteers. And I'll read them all out, and then please applaud for them. Scott Braisted, Scott and Helen Sawyer, Rod Drake, who I think has been responsible for many of the very late night or early morning trips to the airport. Rod's probably sleeping right now for his next 3 o'clock in the morning trip. John Jackson, Rob Jones, Greg and Marcia Leonard, Sid Lyons, who I think I see back there, Peggy Morgan, Tim Petrosky, Danny Vant, Elaine and Bill Windelbow, Tim O'Brien, and my wife and daughter Pam and Aaron. So please give them a round of applause. Okay, I hope I have not missed anybody. If I have, I apologize, but I think I've gotten everybody. So we will adjourn for 25 minutes, and we will meet back here at 2:30, excuse me. We'll meet back here at 2:30 p.m. Thank you very much.